2023. The time is 11 a.m. I'm calling this meeting to order. In attendance are Commissioners Brooks, Matari, and Duncan. Are there changes to the agenda?
Madam Chair, I would request, if you agree, that we take up the MSP Timberland Ranch request for public hearing first out of the chute, just because we have people in the audience here, and it would be much more efficient for them and for us. It's a quick and easy discussion, I think.
Yep, I don't have a problem. Any problem with that?
Nope.
Okay. We can do that. Conflicts of interest today?
None.
Okay, sounds great. So we'll get right into our deliberations, starting with item 5, MSP 22-0009, Timberland Ranch request for public hearing. David, will you start us?
Yes, ma'am. The hearing examiner heard this. It'll be coming before you in the usual way, but I would like to request that we have a public hearing on this one, as opposed to going to deliberations and then you deciding. Because we know there are issues, we know there are things that would benefit from you hearing it all in a public setting, and it'd be more efficient that way. So I would actually appreciate it if you consider it coming from me, that we have a public hearing on this one, even though Mr. Magnuson and his clients have also asked for a public hearing.
Okay. Thoughts?
I'm fine with that.
Sounds good.
All right.
So we'll schedule the hearing and get work with the applicants to get it worked out in your calendar.
Okay, and it'll just be an evening public hearing is
Yes.
what you prefer? Okay. All right, sounds good.
Thank you.
All right, you bet. Okay, item 1, VAR 23-0007, and this is Sonneland. Okay, Vlad?
Good morning, Commissioners. For the record, Vlad Finkel with Kootenai County Community Development. As you stated, this is a request for a variance by Mr. and Mrs. Sonneland for a deviation to the front yard setbacks. The subject property is located in the Kidd Island Bay area off of Boyson Loop, which is a public road. However, it is privately maintained by the Homeowners Association. The parcel in size is approximately, it's a little over 1/4 of an acre in size. It's currently vacant, as you can see. This is a Google Earth overlay. There is development on the adjoining parcel. However, the subject property is vacant, and there's been significant amount of disturbance in preparation for a new residence on site. It is zoned agricultural suburban. The front yard setback off of a public road or from the property line is 25 feet. In this case, the applicants are seeking a variance of 7 feet in order to have the front of their house 18 feet from the front property line. These are some of the photos of the subject property. The applicants, I think they removed some vegetation and have been working on trying to prepare the site for future development. This is the proposed site plan. The front of the residence will have a 2-car garage that will be constructed at an angle, and the closest point of the garage will be 18 feet to the front property line with an encroachment of 7 feet into the front yard setback. The property is very, very steep, and that is one of the reasons that the applicant is arguing that there is an undue hardship and it is not self-imposed, and in order for them to minimize the amount of fill that they would have to bring in order to construct this residence, they would like to be as close as possible to the road to make for a more gradual driveway to their garage. Typically with variances where the argument is being made that they have steep slopes and they'd like to deviate from the prescribed setbacks, we highly encourage, although the code doesn't require it, but we highly encourage that they submit a geotechnical evaluation to make a preliminary analysis on whether or not the site is feasible for development. And in this case, we did get a geotechnical report that basically states that it is feasible to construct a residence on this site from a geotechnical viewpoint. We also have our building division review the request as well as the geotechnical analysis and make recommendations that would require future building permit as well as a site disturbance permit to comply with the recommendations and requirements of this document. During the agency comment period, we solicited comments from all the agencies with jurisdiction. No one really had any issue with the proposal. There was a statement from the Kidd Island Sewer District that they have no objection, but they do have limitation on the amount of effluent discharge that can come from a future residence on this property based on the number of bedrooms that are being proposed. During the public comment period, there were a total of 7 comments, 4 in support, 3 in opposition. Some of their concerns were raised with regards to the proximity of the proposed structure to the public road that is being privately maintained by the HOA. One of the concerns is that there may not be enough sufficient room to plow the snow off to the side. I have driven out to the property, and there are other structures in the area that are much closer than the subject, than the proposed structure. And we find that having an 18-foot space between the road and the front of the house is more than sufficient room for them to move the snow out of the way. We do find that there is an undue hardship. This is not self-imposed. No comments from, or no concerns from the highway district. The hearing examiner heard this request last month and they submitted a recommendation of approval subsequently. I stand for any questions that you have.
Okay, questions for Vlad?
I'm just kind of curious, when you buy a property, how do you have an undue hardship? Or claim you have an undue hardship if you bought the property knowing what it was?
It's a good question. Our code defines what an undue hardship is, and it has to do with the physical characteristics of the site, including slopes, narrowness of the site, limited space for development, as well as irregular shape of the property. So it's not a matter of opinion, more or less, but it's a matter of physical conditions of the property that may warrant a deviation.
Okay.
And maybe Director Kidd will elaborate on that.
Sure.
Commissioners, a couple of things that might help you with this. Hardship and variances have been embedded in zoning codes since the 1920s as a purposeful relief valve because no code is perfect. And there are always extenuating circumstances depending upon the property, how it evolved over time, so on and so forth. What most jurisdictions over time have come up with is the same set of criteria we have. It has to be a physical hardship of the land. It can't be self-imposed, meaning it's not something you go out and create yourself. It can't be economic in nature, so on and so forth. So there's a long history of court cases of municipalities all around the nation using the same kind of approach to variances as we use. And when we say an undue hardship, that really is a term of art now that attorneys use, ultimately, if you will. Does that help at all?
Yes.
Okay.
And that term undue, Pat Braden, Civil Deputy Prosecutor, for the record, just adding to that, the term undue hardship, because of characteristics of the site, is right in the state law that allows for variances.
Okay. And the only other question is really just, what was the purpose of a 25-foot setback to begin with there?
Generally light and air and the general feel of a neighborhood so that when you have a neighbor, you don't feel like they're right on top of you.
Okay.
Is it fair to say it's a way to provide a more uniform way of development of a residential neighborhood?
Sure.
Yeah.
Can also prevent the spread of fire as well.
Yeah. My only concern with it, and it's a simple request, so I'm really bringing this up just for the matter of discussion, is that we have these standards in place, and there's an expectation of what people can expect when they're, when they move in or buy land in a particular area. And, so do we have thresholds that must be met in order to, approve a variance? Or do we just approve them, because they're brought before us? And do we have good reason for it? Otherwise, I don't see the point of having them, if we're gonna have them.
There are specific criteria, both in, state law and more particularized in our code. And so it's not just based on, an arbitrary grant or deny. And they are within the discretion, of the board, not unfettered, but, within the reasonable sound discretion of the board to grant or deny. And they're intended to be only granted in fairly rare cases. Now, of course, in Kootenai County, especially around the lake, you have a lot of lots that have very steep slopes, for example, and other, geological or, challenges or otherwise. And sometimes variances have merit to, just an exception based on undue hardship based on the characteristics of the site, and it's not in conflict with the public interest.
But those standards were set in a geography that was already established, that people knew.
But the county doesn't have a uniform geography, though. Sometimes our regulations end up being a square peg that we're trying to put in a round hole, and it could end up actually, another part of the reason for variances is as a safety valve against regulatory takings litigation as well. That's kind of the ultimate purpose of a variance, is a safeguard against that.
I see where you're coming from. I think it's fair to say that we've discussed, and we just haven't had the staff time to pull the trigger, the whole notion of actually changing the zoning regulations in certain defined areas, because we know that the regs don't really work very well in certain areas.
Yeah.
We just haven't done it because we've been up to here with other stuff.
I think I requested the overlay zone probably 2 years ago, 3 years ago, before everything went totally crazy. So there's places like Silver Beach, there's places that you probably have 50% or more variances.
Yeah.
Because the geography just in those areas don't work. But if we had this overlay, then these things wouldn't come before us, because it'd be more administrative. But yeah, to David's point, it's who knows when it'll happen.
Well, I guess, and I totally understand. It makes perfect sense. We have this one-size-fits-all type, standard, but like Pat said, we have a different geography in different places. I just wonder if there's not some standard that we should at least be looking at if we're going to have these areas and these exceptions.
I think that the zoning, looking at the zoning of those areas, like Commissioner Duncan said, potentially, having overlay zones where, where the setbacks are changed.
We're different.
Yeah.
And I believe, Commissioner Matari, not every variance inquiry comes before you or comes before the director, depending on whether it's a public hearing or administrative variance. At a pre-application meeting, staff goes through the criteria that's assigned for a variance, and we determine whether or not it would meet one or more of the requirements for a variance. So it's only those that have the possibility of being approved that move forward. In very few rare cases have I seen things move forward and be denied because we advise the applicant in advance that it's not a good candidate for approval.
Yeah. Yeah, that's fine. Okay.
All right. Bill, thoughts on this?
No. Well, I guess I would say the ones that come before us generally have a good idea. And we have a good idea of what's happening because of staff's, I hate to use the word vetting, but it's so overused these days. but investigation of each of the parcels before it ever gets to us. I have no problem with the current process.
Oh, I was just, sorry, I didn't mean to interrupt the commissioner's deliberations, but I just had another thought that came to mind. There are times when granting a variance will actually cause construction to cause less environmental damage or impact than it would if they had to observe the regular setbacks.
All right, motion?
I move that we approve the VAR 23-0007.
I second the motion.
Bill Brooks,
Aye.
Commissioner Matari,
Aye.
Chair Duncan.
Aye. All right, variance approved. Item 2, upfront payments of permits. I assume it's this landscape.
Yes, and we have two actual bits of information, but the short version is we're leaving about $300,000 on the table, if you will, right now today, because either these are active permits where we will presumably still collect the money at some point, but we only charge, and historically it's been true for decades before I got here, we only charge a portion of the fee and then pick up the remainder when they actually pick up the literal permit from the front counter. That's the traditional way, and lots of other municipalities do that too. But we're leaving real money on the table. This is $121,000 of money I don't expect we'll ever get because the permits are now expired. And so it's people that went through the process, paid the initial fee, we did all the reviews, but then they decided not to pick up their permit. So I just wanted to have the dialogue with you about do you think it would make sense to start charging most of our fees, if not all of them, right up front when people first apply, which would eliminate both the problem of expired fees and ones where we're still waiting to collect just because they haven't come by to pick up their permit yet.
Do you need some sort of an amended,
It's an administrative action, so I mostly
Administrative,
just need
okay.
direction from the board.
So if somebody starts down the process and then doesn't end up finishing it, doesn't end up doing the project, so how do we address those issues? They would still have to pay completely up front for a service maybe that they didn't get, or?
I'm catching up with you. If, for instance, it's a house permit and you decide midstream that you don't want to build your house, then the worst that happens is you've paid $2,000 or $3,000 in permit fees for something you're not going to use.
Okay.
The reverse, of course, right now is what we're experiencing is there are permits just sitting out there and there's no money being collected. Or in this other case, it's expired and we're never going to collect it, presumably.
So on the expired ones, those are the ones that they just didn't complete their project?
They were never issued.
They just, Christina, you want to jump in?
Yes. Chris Garland for Community Development, Chief Building Official. So on the form you have that has, I think, 2 or 4 pages, the first heading says STP. This document is for all the permits that are sitting in our queue that have gone through all the planning, the building review, and have been all approved and are waiting for permit holders, applicants to pick up their permits after the fees have been paid. So these, with the grand total that we're still due are $189,000, so almost $190,000. What I brought to David, when I first started back in 2015, we took in a percentage of the permit fee. So my request was merely to charge the permit review fees only, so this way if, when the planning does their reviews, the building does the reviews, and the client comes back and says, 6 months or a year down the road, I'm not going to do the project anymore. At least we have gained those fees for the work we have performed. The permit fees, obviously, those are associated with inspections and other reviews that come in after the fact. So that's why I'm requesting at least we can gain those fees. As for the other documents that says permits expired, these are permits that are already issued. So the projects were never completed. So they say they didn't request a final building inspection or a final mechanical inspection. So they end up expiring. We notify them that they're expired. In order for them to get reinstated, there is a fee associated with that. Most times people don't want to do that, so these end up being, they get turned into code enforcement, and now we're spending more money in getting the fees or losing fees for the extra work that we're doing. So just to kind of give you an update on what we're
It's
kind of
a
we're up
lose-lose
against.
situation where we spend money to try and make money.
So is there a happy medium of, or is there a percentage that we could issue refunds for if they did not complete the
The
thing?
full.
So I'd be willing to get money up front if we had a mechanism to refund if they didn't go through the whole process, if they didn't expend the amount of money.
So at this point, we would not be charging the whole complete permit fee.
Okay.
We wouldn't charge them the actual permit fee because that's a separate permit or fee from the review fees.
Okay.
So all I'm requesting is to charge them upfront is the review fees. So this way, planning can get paid, the fire district gets paid, and the building gets paid for the reviews that we did. So whether they're approved or returned for corrections, we actually opened up the plans and did a complete review. So did planning. Planning did the same thing. They did all their research and then come to find out that the permit doesn't ever get picked up and we're out, probably about $1,000 or $2,000.
So thoughts on that?
I'm going back and forth between charging a fee that covers the cost up to that point or charging the whole fee. And the main reason is because we have a certain level of service that's expected, and the county funds the staffing necessary to provide that service. And the question is how many, what percentage of people are falling off, which we know those numbers. It sounds like it's a very small percentage of people that fall off.
It is, I would say maybe 15 to 20%.
Yeah.
It's not a large amount, but
Yeah.
with the fees that are associated with that,
So-
we just don't get those.
So let's
fees
just
paid.
use round numbers of 20%.
Okay.
That means 4 out of 5 people are going to be charged a second fee. So we'll have to ask them for that second fee to proceed versus 1 out of 5 that might be eligible for a refund. And I would almost argue that it would be better just to charge the whole fee up front. Because at least that way, if people are going to pay the whole fee, there's an expectation of completing it. And you probably will end up seeing a smaller percentage of people that don't kind of fall off out of the funnel, if you will. And that way, we are collecting fees commensurate with the staffing level needed to provide the services. And we'll be dealing with the minority on the refunds versus the majority of, by the way, now you need to pay us these X dollars extra for us to go the next step. I think you'll get less grief that way, too.
Certainly a lot less time involved.
Yeah.
Because we spend an inordinate amount of time going back and forth and back and forth.
Yeah, you shouldn't have to be doing that.
So
I think you got a lot less people applying and not fulfilling because they're thinking, well,
I've paid my money.
Yeah, I paid my money, or if I gotta pay my money, I'm not gonna go through with it. I don't think I'll start it.
Right.
And the beauty is, if it doesn't work, we can always
Always
revisit it.
revisit.
So, yeah, let's give it a try.
Thank you.
So you'll charge
We'll,
the full
we'll keep
fee?
you informed. Yeah.
Okay.
Perfect. Thank you very much.
All right, reimbursement request for Lakestone fees. Speaking of refunds,
You recall the Lakestone project, which you've seen numerous times.
I don't recall it.
The person that made the reconsideration request wanted me to ask you to, or actually wanted me to just waive the fee. I told him, I'm not comfortable with that and I don't have the authority, because the authority that you've granted me, in my view, has to do with political subdivisions of the state, like Coeur d'Alene or what have you, where legitimately can waive those fees because it's just taking money out of one tax pool and putting it into another. Here, this person basically in my view, wants special treatment. I don't see a rationale for this, for giving, in this case, $750 back, or the $108 that was spent for the newspaper notice. But I told the person that I would have this dialogue with you. And I realize I've just biased you, but you have my view.
not
of this.
necessarily, because when we were going over the fees, we talked about this, and I don't think that the reconsideration fee still covers your time. So if that's the case, then I can't be in favor of refunding the fees. This is a member of the public who requested a third, how
Third.
many? Third or fourth hearing
Yeah,
on this particular project. So I don't think that I can support that, knowing that it doesn't even cover our costs,
right.
so.
It costs us money to do these things, and without that fee, we open the door to almost this continued, what is the term? Where you slow the process down, and we pay for that, in essence.
Bill?
I agree with Wesley.
It's a filibuster. That was the term. They just filibuster the process.
Yeah,
Okay.
So-
Sounds like you have your.
I have direction, thank
Direction.
you.
Okay. Item 4, code amendment discussion.
Commissioners, bear with me, this all has some context that dates back now, roughly 6 months ago. All 4 highway districts amended their standards. And the one that they changed in particular was on their page 10, where they used to have a mountainous terrain provision where it was possible to design roads in the county with a lesser standard if it was in a mountainous terrain. And that reduced cost for the overall development and actually allowed some projects to go forward that wouldn't otherwise. So the highway districts, that's their call. They decided to take that out. And it angered, it's fair to say, at least a dozen professional engineers that we deal with. Those people have been working on their own to come up with their own code amendment. They've graciously given the staff an advanced copy of it. I have real concerns about it because, for instance, it creates 5 new private road classifications that would be a county standard embedded into the county code. And it would create the need for a county professional engineer to look over those standards. And in my view, it conflicts directly with the highway district's authority, where they have authority over major roads and major subdivisions. This, it seems to me, would create a sidestepping of that, if you will, wherein the county would put its own standards in major subdivisions separate from the highway districts. That, to me, creates an automatic conflict where the highway district's supers would just refuse to sign the plats, I think. And so you see where I'm going with this. I wanted to talk with these group of engineers and just say, I have concerns, and then depending on what you say, I can say the county commissioners have these concerns, because I don't want them spending a lot of time. They have already spent a fair amount. I don't want them spending more time on something that's not going anywhere, if you will.
So let me just see if I'm following this. We have highway district standards. Highway district standards have actually been decreased in this one area.
But in a way, it's increased, because
Okay.
they eliminated a standard that used to allow things to happen that you can no longer do.
Oh, okay.
They
So-
eliminated a lower standard.
Oh, thank you. They
That's what's
eliminated.
weird about it.
Yeah, they eliminated a lower standard.
Thank you.
Okay. And yet, these engineers would like the county to institute a lower standard,
Yes,
but we can't supersede highway districts.
that's my concern. I don't want to create an automatic conflict with the highway districts.
Right. Well,
At the very least, it seems like these engineers need to get the highway district on board
Yeah.
before they come to us.
yep.
I could see a rather large group of constituents who wouldn't have a problem with that kind of conflict, but I don't think that it's, productive.
So that's the way we're made up. You've got elected boards on highway districts, so they have an out, they have a remedy or a due process with them. So,
That helps me, thank you.
Bill?
I agree. To make a carve out where there doesn't need to be one is making things more complicated. I don't.
Thank you. I think I can take it from here.
All right. We've handled number 5. So item 6, variance 23-0008 Skripnik. Say that right, Vlad?
Which means violent layer.
Oh, okay.
Are you logged into, are you in the Zoom?
I'm not, because it's deliberations.
Do we have somebody on Zoom?
No, but since I have it on Zoom, I just wondered if you were.
Typically for deliberations, we just.
It's fair enough, I just wanted to know, because I have it set up, but go ahead, we're fine.
Okay, sounds good. Commissioners, this is another variance request, and I think, going back to the first one I presented this morning, Commissioner Matari, this specific variance request is based on a completely different item list or a different criterion within the variance requirements. This is variance to multiple setbacks. One is to side yard and the other one is to flanking street due to limited space for development on the subject property. The parcel in question is located near Hayden Lake. It's located at the intersection of Stratford and Strathorn, and also abuts Oxford Drive. So there's 3 roads on the west, on the east, and to the south of the subject property. The subject property is very small. It's approximately a little less than 1/4 of an acre in size. And as you can see, it's fairly flat. There's no vegetation at all. There are a couple of the subdivision monument signs. One is on this side of the road and one is on the other side of the road that I believe were there for quite some time, maybe with the original development of this subdivision. And then I believe this is golf course. Is it the Hayden Golf Course, Ben?
Avondale?
Avondale Golf Course? Correct. The subject property is zone restricted residential. The side yard setback is 10 feet and the flanking street setback is 15 feet. So the side yard setback is on the north end of the property, and then the flanking street setback would be along Stratford Drive. As you can see, based on the current configuration of the subject property, the road bisects it, and then there's sort of an irregular shape lot line in this location, leaving a small triangular shape on this side, which technically cannot be developed due to setbacks. However, if you look at the original plat that was done, I can't remember when it was platted. Was it the 70s or the 60s? 67, is that right? Here's the subject parcel in question and highlighted. And you could see it was originally platted to have the public road adjacent to it, providing access. However, we have spoken with the highway district, and so has the applicant, and nobody really knows how the road ended up being in a different location, not along the golf course property line, and how this property line was shifted now to be bisected, to now have the road bisect the property. It's a mystery. I am not sure how that happened. In fact, the highway district did respond. They said, we don't know how this road ended up being further, I believe, north, and then now bisecting the property, and the property line changed to abut or touch this corner where the golf course is. So based on the current configuration of where the road is and the prescribed setbacks, there would be very limited area for the applicant to develop the site. I think the structure may be as narrow as about 15 feet wide if a variance were not to be granted. The code does require that if you have this road is public, it's been considered public based on prescriptive right-of-way, and the code states that the way you would measure setback would be 25 feet from the center line of the road would be the 50-foot prescribed setback right-of-way, and then you would have your setbacks go from that point into the property. So in this case, there would be a 25-foot setback from the center line of the road, and then another 15-foot setback where the applicant could actually construct their residence. What they're proposing is they're proposing to have the northern side yard setback be decreased to 5 feet with a 5-foot variance, as well as having the 15-foot flanking street setback be reduced to 2 feet and requesting a 13-foot variance. That would give them sufficient room to actually build the residence and having the garage on the main floor. And that's one of the criterions within the variance section of our code is like with the first one is undue hardship being steep slopes. In this case, it's not an issue. But the other one is, of course, limited space for development. And we find that it does meet the undue hardship criteria. That is not self-imposed by the applicant, and that it should be approved. These are some of the photos of the subject property in question. This is a rendering of what the applicant wants to build. It's a 2-story single-family residence. We did solicit comments from all their agencies with jurisdiction. I believe the only item that is restrictive is that Lakes Highway District will only allow access on the northeast corner of the property. They can't have access near the intersection or anywhere along Stratford Drive. So that's the only limitation that they would be bound to. There was only one comment in opposition. In fact, when I did a site visit and posted the property, some of the neighbors came out and they did have concerns. They originally thought that this was a non-buildable lot because it was so small. But it is a bona fide lot. It was platted in '67 and it is afforded development rights. However, due to limited space for development, this is a good candidate for approval. We find that it meets the criteria. The undue hardship, limited space for development, Stratford Drive was constructed in a different location from originally depicted, location than originally depicted on the face of plat. This is not self-imposed, and the agencies have really no outstanding issues. And the hearing examiner heard this request earlier this month and recommended approval. I stand for any questions.
Hey, questions? Questions?
I'm just curious, what is the 25-foot variance from the center of the street? What's the purpose of that?
So typically, when you have a public right-of-way, it's defined, there's meets and bounds that define the right-of-way, or as much goes for a road easement. However, if a road has been constructed outside or does not have a right-of-way dedicated for it or an easement dedicated for it, if it's been used for, and Pat Braden could maybe explain further, if it's been used for some time and it goes through court and the court adjudicates it as being a prescriptive right-of-way being used for quite some time, meeting certain criteria, then our code and state law states that now you establish a 50-foot wide prescriptive right-of-way. And so you would offset 25 feet from the physical location of the road, and then beyond that point, you would measure setbacks.
Is that for future expansion, possibly?
No,
Don't
I
know
think
that.
the answer to your question is safety.
Safety? Okay.
Although, David, as you know, with some other projects along Hayden Lake Road, the highway district did anticipate expansion into the prescriptive right-of-way.
Right, but his question, I thought,
It's
the
safety.
Commissioner's question was, why do we have a 25-foot setback? In this case, it's safety.
Oh, I misunderstood. I thought you were talking about the prescriptive right-of-way itself.
I'm just asking, like, we have 25 and then 15 originally, right? And they want to reduce that down to 2 feet next to the 25-foot line?
25 foot is the width of the right, that's not a setback. 25-foot width from the center line of the road each way is the.
You go back to your slide that has the setbacks on it.
Okay.
That's the scope of the width of the prescriptive right-of-way under Idaho Code Section 40-20.
Didn't you have, or is it the other one?
So this is the 25-foot offset from the center line of the road each way. It's to establish the prescriptive 50-foot right-of-way. Beyond that is an actual setback distance that
Yes.
everyone has to maintain. This is not a setback. This is the width of a prescriptive right-of-way.
So the 15-foot, in my view, is a safety issue.
Got it. All right, so the 25-foot is a right-of-way.
Yes.
There you go.
And that's for potentially future expansion if they had to,
Right.
if it becomes a superhighway.
Or just for their regular routine maintenance, so on and so forth.
Yeah.
But both, or either or both.
But they're not maintaining the yard or anything like that.
No, but they theoretically might need to get in there someday for some purpose.
Yeah, okay, okay. That was it for me.
Okay. Thoughts on the project?
I think it's fine.
Yeah, I mean, the highway district approved it, right? So,
All right, motion.
I move that we approve VAR 23-0008 Skripnik.
I second the motion.
Bill Brooks,
Aye.
Commissioner Matari,
Aye.
Chair Duncan.
Aye. Thank you, folks.
Thanks,
11:44, meeting adjourned.
Thank you.